everyone, good morning and thanks for being here. Thanks to my colleague Al4Diag and Francesco Mattini for the invitation. I'm going to have a brief speech trying to cover the time that we have, of course, well spent during the first intervention in order to talk about the general framework about what GDPR is and what are the main issues related, of course, into the healthcare system. So this is the index I'm going to show to you about the European regulation, so general framework, plus the summary of the main changes and impacts, the details of the main legal updates that are contained within the GDPR, and then some consideration in order to introduce the following intervention for my colleague Mrs. Polito, related to the healthcare system in focus on the clinical trial. Related to the first topic, let's talk about the general framework. So the main news and updates that the European regulation number 679 of the 2016 has introduced in our legal framework, plus a really short highlight on how Italy, in particular, has adapted this general framework within our legislation. Of course, given the fact this intervention is dedicated to the European context, I'm going to just to give you an highlight about the Italian decree of adaptation, but of course, I'll be more than welcome to answer to any questions related to the Italian eventual adaptation to this. First of all, brief summary. What is a GDPR? It's a European regulation immediately applicable to all the European member states, so part of the European Union, that is in force since last May 2018. So nowadays we are exactly in the moment where the European regulation is in force. No excuses, no justification. It's our regulation, and every member state of the European Union has to adopt it. Which is the main characteristic of this European regulation that we have heard a lot about? The main update and the main news, let's say, is that the European regulation introduced for the first time in our European context a risk-based approach in terms of the privacy. So nowadays, each and every entity settled in the European Union, or each and every person whose data are treated in the European Union will be subjected to a risk approach-based evaluation. So every entity, every company, every foundation, every time that treats or is going to treat personal data has to make a risk and impact evaluation in order to verify if the treatment of the personal data are minimized, are proportional, and are obtained under consent. So from the company's point of view, it introduced this kind of update, introduced on a certain part a simplification for the fulfilling of obligations. Why? Because the risk approach evaluation is placed on the shoulders of the company. So no more minimum standard of measures, but measures that every company has to evaluate on its own. So certain type of view could be considered a simplification. On the other side, the other view, which is based, as my colleague Bologni was anticipating before, the principle of the accountability, which means that each and every company has to be responsible on how the measures are applied. It introduced a kind of, let's say, a burden to the companies, because you have exactly to demonstrate how you made this accountability in the company, and therefore how you made this evaluation based on risk approach. In few highlights, the main updates and the main news that are let's say the benchmark, that constitute the benchmark of the European regulation, the GDPR. First of all, of course, obligation to obtain consent explicit for data processing. Explicit means evident, not implied. Limitation on the use of automated processes of data to make decisions are example in the case of profiling. If you want to make a profiling process of personal data, you have to obtain a specific separate consent, but separate. Because before, it was implied in the general consent, let's say. Nowadays, any company cannot make profiling process without a separate, specific, dedicated, and focused consent. Then, the introduction of the right of rectification and deletion of data, including the right of oblivion. In a few minutes, I'm going to talk about this new introduction of the new rights related to the GDPR. On the other side, the GDPR introduced more complete and clear information. So the so-called obligation to give complete information nowadays implies that the information needs to be so as clear as a child. I'm following what the privacy authority, the European Privacy Authority, has suggested to us, as a child could understand. That's why we are talking about new information, even let's say summarized with images. So no more information like Bibles, but images, focus. And dear all, in the following months, we're going to assist to sanctions, so eventually penalties, if this kind of information given by the entities, the companies whatsoever, will be not built as a child would have understood. So I would like just to focus this point because it's crucial, it's going to be crucial. Then the right to move data from a service provider to another, well, it was actually factual already as it has been established by the regulation, but nowadays with the regulation it has been written in a really explicit way. Then it has been introduced an easier access to personal data, so each and every person whose data are treated must have the right to access its own data without, the rule says, any particular delay. And if there is a delay, you have to motivate and to justify which are the reasons why you are in delay. And then, as the bell shows, the famous and the so-called data breach hypothesis, which is the right of notification in case of compromise of personal data that the European legislator requires to each and every company that in case of experimentation of compromise of personal data must definitely comply. So within 72 hours from the eventual compromise, companies have to notify to the competent authority this kind of breach, and in case of eventual compromise of the freedom and right of fundamental rights of also the personal data of the owner of the personal data, the companies must also inform the people themselves. On the other side, in terms of technical measures, the GDPR introduced more stringent guarantees for the transfer of personal data outside the European countries. So it's not going to be easier then for the companies that treat data outside the European Union to do so without specific guarantees or specific compliance with the so-called standard clauses that are accepted by the European Union. So in few words, if you are an entity that contain and treat data that are going to go outside Europe or to a server, to a machine, to a database located outside Europe, you have exactly to identify where this kind of data are going to go and verify if the country extra EU where you are going to transfer your the data are under the European Commission approval. That's why normally to my clients, to my companies, to the students where I do teach to, I normally say that GDPR requires us a prodromic evaluation. So before doing anything, you have to ask, where is the place, the machine where I'm going to go, where I'm going to transfer my data? If I'm going to transfer my data to the United States of America, am I sure that this kind of provider has been accepted by the European Commission? So beforehand, I have to ask myself, am I privacy compliant? What I'm trying to do, is it privacy compliant? Not after, because it's going to be too late. Then, of course, on the other side of the moon, we have that if you're not going to comply to all these kind of requests and obligations given by the GDPR, the penalties are more than doubled. The penalties will come up to 20 million euros and up to the 4% of the annual turnover of the total amount of the balance of each and every company that in case made a compromise of the personal data. At the moment, at least I'm talking about Italy, we have not yet experimented severe penalties, but what I heard is that starting from the last 20 of May, at least in the Italian context, there will be no more excuses, and therefore our system will make this kind of obligation definitely applicable without any legal justifications. In terms of Italy, talking about just a brief highlight as promised on Italy, what really, according to me in this context, is worth to say is that in Italy we have introduced, or the decree number 101 of the 2018 has introduced, is that according to the concept given by child, nowadays child can give a concept in the field of information services that we have to better understand in the future. What is information services? Nowadays it's pretty clear that we are talking about social platforms and so on, but who knows if our Italian authority will better specify that for information services we can interpret this kind of wording in a more broader sense. On the other side, the Italian legislator has also promised to micro, small and medium enterprises a more simplification in terms of adoption of the obligation given by the GDPR. So we are going to see what Italy is going to do in order to simplify what actually you have just talked about. So the obligation given by GDPR. So in few words, if you're going to be, your treatment are going to be limited to the Italian Republic, you have not just to comply, therefore, to the GDPR, as mentioned, but also in case to the eventual regulations and guidelines of the Italian Privacy Authority. So definitely you have to be updated month by month. Let's go in detail about the main legal updates of the GDPR that I've just anticipated. Trying to be as more efficient than I can in order to summarize what you can obtained from my speech. The main updates are exactly listed here in the slide. And in order to go in details, let's start with the first point, which is actually what I've mentioned before. The concept of privacy by design and by default. The concept or the principles, privacy by design and by default imply that the privacy nowadays must be incorporated ex ante from each and every process, system, procedure within a company. So you cannot process and start the treatment before having asked to yourself, did I build up, did I establish this process as a privacy compliant, in privacy compliant with a regulation? If you don't do that, you can risk, of course, penalties. The definition of the sensitive data, so basically the so-called particular categories of data, more or less is the same that we have taken exactly from the Italian Privacy Code, because the sensitive data are nowadays the racial and or ethnic origin, opinions, policies, religious and philosophical beliefs or trade union membership, as well as the biometric data, genetic data, data relating to the health and sexual life or orientation, sexual behavior of a person. So if actually in Italy, this kind of data before needed a specific notification to the authority, nowadays, we just know, according to the GDPR, that the consent needs to be explicit, separate, evident in terms of category of data where you are going to have the consent for. But nowadays, if you're going to have just a treatment in Italy, we are not talking anymore about notification to the privacy authority. We are going to say if the Italian authority will change its opinion or not. And of course, each European member state will adopt its own regulation in correspondence to the sensitive data that, of course, need a more specific and explicit attention. Registry. The registry is another obligation that in some cases it's mandatory, in some cases, which means that some companies that do have specific profiles like public entities or public participation entities must have, which is a registry of all the treatments of personal data that the company or the entity process during its work. So it's really recommendable, however, even though you are not under the compulsion, to maintain updated register of all the processing activities. Because if you will experiment any control, if you show up to the finance or to the inspections of the Italian or any other European countries' inspection authorities, it's going to be easier and definitely more compliant with the regulation if you have a registry where you have basically underline and schedule all the personal data treatment, and of course notice and mention that for each treatment who is going to be the responsible, the person in charge, and of course that you have obtained all the separate consent for all the database of the personal data that you are treating. Data breach has been already detailed before, so I'm going to skip exactly to the right of the interest parties. The introduction of the new rights of the interest parties is one of the more interesting and important update of the GDPR. In particular, our European legislator has introduced the right of access and rectification that was actually already present in more or less all the European countries. Right of data deletion, which is of course the right to have the deletion of your personal data because you don't want you basically retire the consent from the owner. New introduction of the rights is the rights to limitation of treatment which is the right given to an interested party to request the limitation of the processing in case of illegal, so not lawful processing, or when you are not so sure about the legal accuracy of your personal data. The right of data portability, another introduction, is the right of the interest party to obtain from the data controller, so the owner, your personal data in order to transmit them to another owner without any burden. And then the basically two other already existing rights in more or less all the European system jurisdiction, the opposition right and the right to lodge a complaint, which is the right to access to the authorities and the right to oppose against, of course, the owner and unlawful treatment of your personal data. Last but not least, the last new introduction of the right, which is the right of oblivion, where basically your personal data are no more necessary for the purposes for which they are collected or processed. You can exercise the right to revoke your consent, and so to obtain from the data controller the deletion of the personal data. Of course, these rights need to be proceduralized, which means that all the employees, all the eventual responsible of data within the entity need to know exactly the procedure to make the interested party exercise their rights, which is not obvious. I mean, what I'm trying to say is that these rights must not be simply a frame, but you have to give instructions to your employees, collaborators, whatever, to establish, to make this right live, possible from the interested party. Because if the interested party, for example, in the future will exercise the right of, let's say, opposition, but then you don't respond to the right of the interested party, you can risk, however, penalties. You don't respond, or you respond with delay, which means that every employee needs to be exactly formed and instructed to do so. So procedures internal to the companies. Transfer of data to third countries, I mean countries outside Europe. I have already talked about that. And definitely, just in order to summarize, the information and consent and the specific consent, super news, as I was saying before. Do not forget to take the consent in an explicit, simple, intelligible way. As much as I can, I'm trying to spread this kind of culture, because according to me, is one specifically, well, of course, I'm talking specifically about Italy and Spain, where I do have experimented some complaints and some legal proceedings. Honestly, nowadays, the authority is really, really sensitive on information that are not concise, intelligible, and, let's say, summarized. And honestly, I have experimented just a few weeks ago that the privacy authority has given a penalty, well, nowadays not so high and so severe, but to a company whose information were not so easy to be understood. So please focus on that, specifically in your field, which is not so intelligible for interested parties whose personal health, genetic data are treated. Mind the gap. The last news, and then I'm just going to give you some anticipation about the clinical trials and the relationship with the GDPR, is that the European system is pushing all the companies, therefore, to specific code of conduct. What is a code of conduct? The code of conduct are certification codes, so internal codes, that the authorities are suggesting specific entities in specific sector to adopt. It's like a quality mechanism of certification where if you develop these codes, you risk less, and basically you can oppose to the eventual inspections that you are coherent to a code of conduct that in the state of the art of the field where you are basically complying with. So it would be really a very interesting for you. I'm just launching a, why not, like a suggestion that for those that are in this kind of field, so field of healthcare, clinical trials, to adopt a specific code of conduct to be certified by the authorities in order to be aligned, and that to all of you adopt a same mechanism, a same regulation. Of course, it is internal, but as long as it has been certified by specific certified authorities, definitely your situation will be more protected. The last 2 points is that under the so-called risk-based evaluation, risk-based approach that the GDPR is based on, the data protection assessment, so basically the assessment of the impact processing of personal data protection need to be run each and every time you are going to start a new treatment. So every time you are going to acquire, for example, a new database, you are going to transfer your data from a server to another, from a company to another, you have every time to conduct a data protection impact assessment with your consultants, within your internal fields, with your data protection officer, which is the one, basically the person which is a new professional figure that has the duty to monitor and control the compliance to the privacy obligations of the companies. In some cases, this kind of figure is mandatory. In some other cases, actually, of course, it's not. But according to my experience, I can say that it's, in this moment, the best practice is that independently from the fact that a DPO is mandatory or not, is a very good practice in coherence with the code of conduct I was talking before, to have someone explicitly instructed to be and to become a data protection officer. It's a very definitely good way, again, to protect your company, your entity, in order to show up that you are privacy compliant. Few words in order to anticipate my colleagues' intervention about the relationship, and so definitely the link of the GDPR in the healthcare system, focusing in order to avoid to double our intervention just on the recitals of the GDPR that normally are not very often analyzed and studied. But for me, working in this field and teaching in this field are more important, because give to a jurist the tool to interpret the regulation, the articles. According to the recitals 33, 34, 35, 50, 156, and 59, we have exactly the definition of what are, according to the GDPR, the generic data, because you are not going to find exactly out of the recitals a specific definition of it. What are the health data, and mostly which are the processing of this data that are allowed? What I mean that, of course, given the fact the principle of the GDPR and all the member states' decree of adaptation is without consent of the interest party, you cannot treat any health sensitive, let's say, data. It's also very important, however, that you can treat these data for further purposes, as long as, that's the point, as long as you have a legitimate interest to do so. So you are able to demonstrate in front of eventual inspection, and you are basically able to show that these further treatments can be justified with a public or legitimate interest, you are allowed in any case to go further the original consent from the interest body. So basically, in order to do so, what do you have to do? First of all, complying with the majority security measures like pseudo-anonymization of personal data, minimization of personal data, which is evident, and also archiving this personal data like what the recitals 159 says. Here you have, in order to demonstrate that part of the legitimate interest is the development, the demonstration of the fundamental research, the applied research, and any kind, here you have, of purpose that is related to scientific research, including studies carried out in the public interest in the field of public health. According to me, these are the two interesting, so the two recitals that could give us a new field in the field of the clinical trials, in the field of the healthcare system, a very interesting point to be analyzed and studied. So the public in their interest to, let's say, archive and to obtain and to treat personal data for further purposes, as long as you are able to demonstrate that beyond there is a public legitimate interest for scientific research. So let's go and study more this kind of, let's say, holes that can give, according to me, to your entities, light, hope to treat and to continue the street of the research in the public health. Thank you very much.